UK, in Australia, and a number of other places, um, uh, all have noted that there is this phenomenon, this observer effect. So police tend to change their behaviors when they know they're being observed. And I think that's really important. So, most legal observers will wear some sort of brightly colored bib. In Ireland, we have a nice orange color with a legal observer logo and a name marked on the back. Um, and I think that's there to mark us out as somebody separate and distinctive. Um, it's also really important to note that we visibly document what's going on, right? So we encourage people to go along with clipboards or with some other kind of way of marking out that they're different and that they're doing something specific. Very often they will visibly go up to the police at the beginning and take down badge numbers as a way of marking out that they are observing and making their presence felt to the police. So that's in the course of the protest. In the immediate aftermath, where particularly where there's been something untoward going on during the protest, then it's really important that the report writing that we do on a kind of everyday basis for all protests, that gets put together into some shape or form of public-facing report. So in the immediate aftermath of a problematic protest, then we will publicly report on the use of force, the abuse of police powers, the absence of policies, perhaps governing police powers, or the secrecy around those. In Ireland, the Garda Síochána, the police force, are highly secretive about a lot of their policies, and so that makes it sometimes quite difficult to measure exactly what's going on against the policies which they claim to have. Um, we also feed into defense cases sometimes for protesters. Um, Other legal observer projects around the world have pushed for public inquiries in the aftermath of controversial policing operations. And on top of that, in the immediate aftermath, we often will feed into public narratives. So the fact that the legal observer projects are independent is really important because that means that it can't just be reduced to he said, she said, so the police versus the protesters, where the protesters' voice often gets drowned out by authoritative statements from the police. So the legal observers try to balance that a little bit and give an independent, authoritative statement of what occurred. And so that sometimes means feeding into the media. Sometimes that means feeding into social movement processes and organizational processes like that, and other forms of organization. So that's kind of immediate aftermath of the protest. In the long term, and I think this is something which is maybe less remarked on, at least in the academic literature, but I think there's a really important function of legal observers of gradually accreting data about the way in which protest policing occurs, and in particular about the shifting nature of protest policing. I think sometimes we get caught up in the spectacular, the big, terrible protest policing, but we miss that there is also this really important piece of work around the slow monitoring of the changing nature of protest across years, decades, maybe even generations, right? And so the legal observer projects that are up and running, some of them since the 60s, I think have this immense wealth of data, which I think is a really important source for us to think about. The Irish Network of Legal Observers is only going 18 months, so our data is comparatively thin. Um, Okay, so that's the first thing. That's how we conceptualize what legal observers do. The second thing maybe to talk about is the recognition of legal observers at an international level. And there's a bunch of international human rights norms which are really helpful for understanding the particular protections that legal observers should be getting. Um, I'm going to start with the Organization for Security and Cooperation in Europe. I saw Michael Hamilton is here. I think he was involved in writing a lot of this as well. But they have a really useful set of documents, and in particular, they talk about the responsibility of states to facilitate the presence of legal observers at protests. I think that's a really important thing to note, right? It's not just that that states shouldn't be beating up legal observers, but actually that states have a positive obligation in some shape or form to facilitate their presence in the protests. Um, and I think it's important to think about what that might mean, what it means not just to refrain from doing harm, but actually a positive obligation to do things. So the UN Human Rights Committee's General Comment 37 also helps us out here. There is a very short paragraph 74, in that general comment, which mentions observers specifically. It says, the freedom of assembly affirms the duty of police to protect journalists, monitors, and observers, medical personnel, and other members of the public from harm. So it again puts a kind of positive emphasis on a duty to protect, in some shape or form, legal observers in the context of protest. That's a particularly important one because it is the authoritative reading of Article 21 of the International Covenant on Civil and Political Rights. So it has maybe more of a standing even than the OSCE's comment in terms of international law, at least. Crucially, this looks like an elevated duty. So a state having a duty to provide a higher level of protection to legal observers than ordinary protesters. And I think we see that again in the UN Declaration on Human Rights Defenders, and in particular on the commentary on that declaration. So the commentary explains that legal observers and other monitors should be protected during protests, suggesting again an act of exclusion from the use of force, whereas it explains that ordinary protesters should not be subject to excessive use of force. So legal observers should not have any force used against them, whereas protesters might have some reasonable, proportionate use of force against them. So I think at an international level, we can begin to see, uh, not just a recognition of legal observers, but some shape or form of the beginnings of a nascent requirement to protect them in lots of different ways. This is something we always emphasize at the start of our training for the Irish Network of Legal Observers, and but we also feel like we need to pair it with a second observation, and that is that we all know, anybody who's involved in human rights work around the world, particularly around protest, we all know that there is often this yawning chasm between international protections and the norms and so forth, and what that actually looks like on the ground. So the question that our observers sometimes ask us, and which we definitely make sure to explain to them, is what use are these international protections on the ground when you're faced with a hostile police officer? And I think the answer feeds into two levels. So on the ground, it's often helpful for observers to explain their role to police, to make police aware that they're not protesters. And in particular, if police dispute the role or dispute the independence, as we've had a number of times, dispute the independence of the legal observers, then being able to point to these international protections is powerful in a rhetorical sense. So, there are various claims that can be made around the international protection by the UN of legal observers, which on the ground may be convincing to a police officer, or at least may persuade them that they should think twice before taking a really hostile action. So if the police dispute the role of legal observers, this is something to pick up on subsequently then in the reporting that's done after the event. And that can signal that the state isn't taking its obligations seriously. So that's the first thing. In the moment, it's useful, but at the same time, I think it's also really helpful to use these set of international norms to begin to push states to recognize that they may have international obligations around legal observers, and to recognize that they need to accept that international obligation and do something to pass it on to their police force. So we were thrilled recently after an interaction between the UN Special Rapporteur on Freedom of Assembly and Association and the Irish government, where the Irish government recognised that it did indeed have an obligation towards legal observers, and that they would do something around promulgating that to the police forces, or the police force in the Republic. So I think that's a useful set of norms then to push for, greater protections from the police force. Okay, that's the second observation I wanted to make. The third observation I want to make is around the question of independence. Um, and I'll be quick because I think my time is running out. So this is something we often get in the field, from police, from the media. We also got it in the academic article which we published recently at the Journal of Human Rights Practice, which is open access. If any of you want to go and have a look at it, it's freely available. So a lot of people ask questions about what independence means in this context, and I think that's based on this intuition that a lot of the legal observers are people who are involved in protest themselves. And so I think one distinction we draw here is between the difference between neutrality and independence. So it's the legal observers are not neutral. They're there to protect the right to protest. There to protect protesters' rights in that sense. So they're not neutral, but they are independent of both the police and the protesters. The other thing which I think is really important that we've pushed is that independence doesn't mean that, before a protest that somebody hasn't expressed a view on what's being protested. Like we have a lot of Palestine solidarity protests in Ireland. And maybe the legal observers express views on Palestine solidarity before the protest. But the second they put on the bib, they then take a position of independence. So we in the article we theorized it as a kind of social identity, right? That by agreeing to act as a legal observer, by putting on that bib, at that moment you become independent of everything else around you. Um, and so in that moment, they have to be guided by the values of independence. They have to put aside whatever socio-political commitments they have, whatever professional knowledge, whatever experiences they have, and in that moment, they have to act in this particular role. And thinking of that as a social identity, an identity which is taken on in that moment and exists for so long as they exercise that authority within that particular uniform, I think is a really useful way of thinking about it. Um, I'm going to leave it at that. I think I've gone 2 minutes over my time, so apologies for that. But I'll hand it back to Emily.
Great. Thanks so much, Illan. That was a really helpful overview of what the legal observer role does and how we've conceptualized key issues. So I'm going to speak to you about our experience developing the Irish network of legal observers over the last year and a half. So ICCL has previously been involved in legal observing before in the 70s and 80s, and more recently during Shell to Sea protests from about 2000 to 2013. But in more recent years, we haven't had any engagement with legal observing until now. And the lack of protest monitoring was something that came up as an issue following protest consultations around the country that ICCL did in 2019 alongside INCLO. So these consultations found that there was a number of emerging trends with the right to protest, which continue today and in fact may even be amplified. So things like criminalization of protest activity through the Public Order Act, a lack of protest monitoring, criminal law equipping Gardaí, so the Irish police, with very wide discretion to police protests, and a lack of guidelines and transparency. Moving forward to 2024, ICCL co-hosted an all-island seminar with our sister organization in the north, the Committee on the Administration of Justice. And the key emerging theme or recommendation from this seminar was that ICCL should endeavor to create a new generation of legal observers. So this seminar gathered activists, human rights organizations, community tenants units from across the island of Ireland, and everyone there thought that a legal observer project could help serve an important function, namely what Illan referred to by providing that independent, objective account of how protests are policed and comparing them to human rights standards to really combat this he said, she said narrative that can emerge with An Garda Síochána in the media. So in 2025, we had applied for specific funding to do this work from Research Ireland, and we were fortunate enough to receive it. And that led us to really going full steam ahead with the webinar. So I think in 2025, we held 10 trainings across the country. We went to all major cities and also smaller rural areas. And we wanted to make sure that this project was brought across the country and not just based in Dublin, to make sure that we had coverage of protests that would emerge across the country, particularly in hotspots such as Shannon Airport in County Clare, where there are frequently protests regarding the role of the US military at Shannon Airport. So, Illan briefly mentioned this, but there are different types of legal observer projects around the world, and we thought it was really important for us to combine what we called the social movement model, the lawyer model, and the civil society model, because we wanted to draw on the people who are in the social movements in Ireland to really lead this. And I see we have some observers on the call here today who are key figures in movements such as the Palestine Solidarity Movement, but we've also got observers from tenants units, unions, student unions, and beyond. So initially what we had done to recruit people was to reach out to different individuals who had previously engaged with ICCL on the issue of protest in the past. And from there, it really spread by word of mouth and just from people getting to know us and our work, and also the role of ICCL's social media as well. And we decided to do this as a collaboration between ICCL and the Irish Centre for Human Rights at the University of Galway, because we were able to draw upon both organizations' extensive networks and experience engaging with the policing and criminal justice system, but also our network within the broader Irish legal community. So we could engage with both individuals who are involved with protest movements, but also individuals who have the legal expertise around public order policing, criminal law, and similar issues, to have this well-rounded group of individuals who are really committed to the right to protest. So our trainings are on average about 3 hours long, and we break them up into three parts. So the first session covers what the role of the legal observer is, very similar to what Illan just spoke about. And the second section is the meatiest, for lack of a better word. It goes into detail what the right to protest means in Irish criminal law and the different powers that are given to Gardaí to police protests, and also Garda powers generally that could be used in a protest. So things like use of force and arrest. And we conclude with a session on practical legal observation skills. We've had some mixed success in doing a role play. I think in the Australian experience, role play is quite successful, but in the Irish context, some people are allergic to it. So it really depends on the group. The training is iterative, so we have adjusted it based on the feedback we've received, and it is dynamic. So we've done it. I think we've lost track of how many times we've done it now, 12 or 13, and we're constantly looking for the ways to make it most useful for people so that they will have the skills to document how protests are policed in Ireland. So one important point about our network is that we actually we sat down and we wrote 7 guiding principles to guide the network. So this includes things like to be independent, to not act as protest marshals or stewards, and to not give legal advice. So we wanted to have these guiding principles as parameters for the role, and for something that legal observers can always return to guide how they should be behaving and observing in the field. One guiding principle that has prompted questions from certain actors, including on Garda Síochána, is our principle that the network does not support groups that infringe on or undermine the human rights of others. So in practice, this means we do not send legal observers to groups that are hosting things like anti-immigration rallies or anti-trans rallies. And we made this decision because we see the right to protest as an enabling right and a tool for collective liberation. So we do not want to send legal observers to protests where essentially they are calling for rights to be removed from certain groups. So this is something that we have been questioned on rather publicly, but we have taken the decision to stay firm with this point. And I believe Anastasia, the Legal Observer Project in New South Wales, has done a similar point. So this is something we also looked at other projects to see what they did at the very beginning. And we are very proud to continue that as protests continue to emerge in Ireland. So in terms of the volume of protests and how many protests we've had observers at, in 2025, we managed to have observers at 70 protests across the country. So the majority were based in Dublin, but we did have a significant number of observers at protests in Cork City, but also at Shannon Airport. So it's really good that we're not getting data just from Dublin, because we've learned that protests are policed in a very specific way in Dublin compared to other parts of the country. Aside from Shannon Airport, Dublin really seems to be the place where it's policed the heaviest, whereas protests in places like Galway City or Cork City generally experience a rather hands-off approach. One other governance decision we made was for the network to be overseen by a committee of 5 experts in the area of human rights, policing, and civil liberties. And we wanted to do this to give ourselves a little bit of credibility, as the network is quite new, and also as it was not a group that emerged from the community, but rather a collaboration between ICCL, an established human rights organization, and Illan. So they have been really helpful in setting the direction of the network and providing overall strategic guidance for what we're doing. So overall, we've had rather quick success in terms of building the network and getting individuals interested who want to train as legal observers. But we've experienced more challenges in engaging with An Garda Síochána to discuss the role of the legal observer. So, like Illan mentioned, we did have a really good result from that recent engagement between the UN Special Rapporteur on Freedom of Assembly and the Minister for Foreign Affairs. However, when we have had meetings with rather senior people in An Garda Síochána's Human Rights Unit, it doesn't seem like the message has trickled down from one ministry to another. And we also wrote to the Assistant Commissioner responsible for protest policing and community engagement following a protest in October, where we witnessed multiple violations of the Garda use of pepper spray policy and disproportionate use of force. We wrote to her in November, I believe it was, and we only received a response 2 weeks ago. So we are experiencing some challenges in terms of accountability and really getting the police to know what the role of the legal observer is and what their value is. So moving forward, we hope to continue to take this training across the country. We've had many in Dublin, but we would like to return to other areas to make sure we have equal representation of legal observers present at protests nationwide. Another idea we have is, even though there's a different legal framework regarding protest in Northern Ireland, it could be something to have an all-island legal observer network to monitor trends. And this could be particularly useful for people who engage in protests in both jurisdictions. So the Legal Observer Network, just to conclude, is now a huge part of ICCL's work on the right to protest. And this work will only continue to grow in its importance as Ireland does take up the presidency of the EU Council on July 1st. So we are likely to see more protest and dissent emerging. So I think I will finish there and I will hand it over to Anastasia.
Thanks so much, Emily. And yeah, such a pleasure to be here tonight and to connect with you all. So I'm dialing in from unceded Darawal land in Sydney, Australia. I'll speak a bit about the genesis of Legal Observers New South Wales. Legal observing has quite a long history in Sydney. So the first recorded instances of legal observing came from First Nations people in an inner city area of Sydney known as Redfern, where they were monitoring the discriminatory use of police force against Aboriginal people in the 60s and 70s. And that project eventually actually became the Aboriginal Legal Service, which was the first Aboriginal run community legal centre in Australia. So that history led to a series of Legal Observer projects that kind of started, faded on and off over the following decades. And we are but the latest iteration of that lineage. So Legal Observers New South Wales started in earnest during COVID. Again, and I'm sure you've seen this in Ireland as well, often waves of protest repression bring new infrastructures and capacities into movements. I think that's what happened with Legal Observers New South Wales. Again, COVID regulations were being particularly misused against First Nations protests and protests by Muslim communities. So the first protest that we observed at was the Black Lives Matter rally that the New South Wales Police actually attempted to ban under our protest legislation. And that was the first time that we had a team of legal observers. We weren't known as legal observers then. And then we sort of actualized as an organization in 2021 with the sort of inside a network that included certain civil society organizations, but mostly informed by existing movement infrastructures that had emerged from this period of intense restriction on the right to protest. And I think that kind of movement DNA has been a big part of how our direction has been shaped. So myself and Alison Whitaker, who was the other person who was really instrumental in the founding of Legal Observers, I think we both had quite significant community connections to a number of different activist movements. And that's really shaped the sort of social movement approach that we've taken on, where we have a real focus on movement relationships. And while we observe at the protest for sure, we kind of have, in effect, a whole of protest coverage, so before and after the protest. So that includes hearing about things like when police are putting pressure on organizers around where the march route will go or how long they're going to stay somewhere, or misrepresenting the law to them, to after the protest, if there are repressive bail conditions placed on protesters, if there is surveillance, if there is home raids, etc. And Illan, you noted earlier about the changing trends in policing. So that's something that, because we have this kind of whole picture, we can see how policing of protests in Australia is moving towards that strategic incapacitation approach, where protests are really seen as almost organized criminal activities to be disrupted ahead of time, rather than that negotiated management approach that was commonplace across much of Western liberal democracies earlier. So because we have those connections with movement groups around New South Wales, we've gotten reports of things like, preemptive visits to people's homes before a protest, police saying, if you go to this protest, then you could be committing an offense, or people being pulled over on the basis that their details are in the system because in connection to an earlier protest. So that kind of connectivity has been really important for creating that comprehensive picture of how protest policing has changed. And we've collaborated with other institutions to create that fuller picture. So I've put a link in the chat of our reports page, but also a report that our observations were used in by the Australian Democracy Network that pulled together the legal observing data around Australia for the last 5 years to create sort of a comprehensive picture of how protest repression was shaping out. And I imagine the situation is similarly bleak in Ireland, but having that picture meant that when these individualized cases of really bad police violence happen, media and commentators and civil society can frame them as part of a broader pattern and say, this is actually a policy issue. It's not a bad apple, and it's not just, the cops were really crazy that night, I don't know what came over them. This is actually part of a sustained strategy. So building that picture has been really important to us. And on a broader level, the reporting that we've been doing and trying to get those reports out quite quickly after the protest. Often I've been at the end of a protest on my phone typing up the first draft of the report, has enabled us to play a kind of witness function for protest participants themselves, often violence at protests can be it can be subtle. It can look like pushing. It doesn't always look like broken bones. It can look like someone being misgendered by police. It can look like being asked to give ID when you didn't have to. It's that general intimidatory effect. And for us, reflecting that back to people and saying, yes, that happened, and that wasn't right. That's been really important for building a movement sense of human rights as a lived thing, not just as an abstract reality. So saying these are the rights that were violated, even if there isn't often legal recourse for actually pursuing that violation, has been a kind of, I suppose, confidence building strategy for people that they do have rights and they can still assert them in the public discourse and for advocacy, even if the legal mechanism to pursue them is often quite constrained. And that kind of confidence building movement relationship role has also manifested in how we train and talk to people. So we do a lot of community legal education through our online resources, but also we have legal briefings quite often for specific protests that are happening that are tailored to that protest situation. We have general legal briefings as well. We run workshops for people on how to resist repression using legal means, advocacy means, how to use the language of the state against itself, and kind of giving people, that human rights language where they can assert that they are in fact rights-bearing subjects. On a broader level, with the legal system itself, we have often helped to connect people arrested during protests with legal support, or people who might have civil cases with legal support, encouraging them to pursue civil cases. As many of you would probably know, it's often kind of a part-time job or an extracurricular activity, actually trying to get to a place where you can have a successful civil challenge against police. And many people in this space don't have a good relationship with the legal system and don't believe in the legal system for very good reason. So playing a bit of that translator role and showing movements how the legal system can be useful to them and to the protection of protest rights more broadly, putting their individual experience in the context of this broader repression that we've just spoken about, is another way of making, I suppose I think of it as like making that awful experience mean something, right? Because really we talk to people who have had really harrowing things happen to them and they think, why would I talk about this publicly, or why would I go to the courts about this? It's not going to achieve any kind of justice. And I suppose in a way, what our project is about is saying that if you can tell the story and the story adds up to, the state has consistently violated people's rights and people claim those rights in response, then that won't have been for nothing. And that's not the kind of justice that we sort of see represented in legal textbooks, but that's kind of a bit closer to how justice works in the real world. I think my time is almost up. So that's a very, very quick overview of the things that we try and do. Links are in the chat, and just happy to be here.
Thanks so much, Anastasia. It was really great to hear about your work and just really inspired by how your work is so guided by the community. And in addition to legal observing, you're also doing great things like the workshops on how to resist repression and using the language of the state. That is really excellent and I think much needed because I know sometimes if you're not familiar with the state framework and the language, you can really just get bogged down and give up. But it's important that we do push back. So I will turn it over to Sarah now, who will speak about HRLC's work in terms of supporting legal observer projects in Victoria and recent litigation. Over to you.
Thank you so much. It's such a pleasure to be here. I was speaking to Anastasia earlier today in the daytime in Australia, but it's nice to see everyone internationally. And so I'll speak a little bit about just the HRLC's perspective on how legal observers have really helped our work in so many ways. And I think the work that we do at the Human Rights Law Centre, we don't have a legal observer program. There's legal observers that exist in New South Wales and in Melbourne. There's and legal and some sort of more informal legal observer groups around Australia, but these groups are really critical to providing us with, I guess, the evidence, the on the ground evidence base to understanding what is actually happening at protests. I'll speak a little bit about some of a recent piece of litigation that we ran, which was really only made possible through the Legal Observer Group in Melbourne. And I think, you know, just one of many examples of ways that legal observer groups can really practically work with solicitors and litigation teams as well to pursue positive reform. So the case that we ran recently was concerned a decision by Victoria Police to declare the entire Melbourne CBD to be a designated area for a period of 6 months under a particular weapons-related act in Victoria. What that declaration meant is that within that area, police had the power to conduct warrantless stop and searches without reasonable grounds, power to require people to remove face coverings or leave the area if they refused. And although that sort of these designated area powers, and I think we see this sort of across the board, and we're seeing it more and more in Australia, where we have broad policing powers that are often responses to crime-related panics. And in this case, these laws were introduced in 2009 in response to knife-related youth crime. And whilst initially these broad powers granting police broad rights that they wouldn't otherwise have were used for crime-related operations, over time, these powers have begun to be used more in protest contexts. And the reason that we know this in Victoria is through the work of Melbourne activist Legal Support, who has documented this over many years and documented that from 2017, these powers started to be used in protest contexts, despite no evidence of weapons-related risks. And in 2017, that also aligned with the powers being expanded to not just allow police, not to just give police the power to use warrantless search powers, but also to require the removal of face coverings. And that explicitly, that provision targeted coverings used to protect people's identity or to hide, to disguise their identity or to protect against crowd control weapons. So really sort of explicit language tying those powers to protest events. And what that has meant is that in designated areas, people attending protests who wear face coverings can be required to remove them, or they have to leave the protest area. And it has directly affected, and this as well has been documented in the protest context, affected people who need to wear masks at protests for health reasons, for cultural reasons, and as part of their political expression, and has, you know, really has created a permissive environment for the use of force in circumstances where those people refuse. So with this case, we acted for 3 applicants, Tyneen Onus Brown, who's a First Nations organizer who organizes our annual Invasion Day rallies, which are one of the biggest sort of First Nations day of mourning for First Nations people around the country, signifies the invasion of Australia. And this designated area was going to be in force at the time of the Invasion Day rally, which is one of the largest rallies in Narmore, Melbourne. We also represented Benny Zabel and later someone called David Hack, who I'll speak a little bit about. We had to file the proceedings within about a week of the declaration being made, and the matter was urgently heard within a couple of months. The case, and I won't speak in detail about the case, but it was both an administrative law challenge, a charter challenge under our Human Rights Charter in Victoria, and a constitutional law challenge. And ultimately, we were successful in that the designation was declared unlawful and invalid. The court accepted that the police had incorrectly construed their statutory powers. For the first time a designation was challenged. The court found the decision was affected by jurisdictional error. We also challenged the face mask removal power on constitutional grounds, and that aspect of the case was not successful, but the court reached that conclusion on the basis of their really narrow interpretation of the designated area power, and has left open the opportunity for future challenges. And as a result of the case, I think that there have been no designated areas that have been declared since under this particular power. And I think it has affected sort of the protest landscape in Victoria. And just to go back to legal observers, so yeah, as I said, the case was really only made possible through the Melbourne activist legal support. Normally it's incredibly difficult, as I guess the lawyers who are watching know, to bring legal challenges in such short spaces of time. Often, you know, in Victoria, a declaration will be made within 48 hours of a protest being called, and there's very little scope for lawyers to bring an administrative law challenge in the state superior courts to challenge it. The reason why we were able to bring the case within such a short space of time is that the Victorian government had been proposing for a long time a broader ban on face coverings at protests, which I know other jurisdictions are also proposing. And this is something that MALS has been documenting, the Legal Observer Group in Melbourne has been documenting for many years, the use of face unmasking powers at protests. And so with MALS, we were able to identify relevant plaintiffs. So in regard to the Victorian laws, we started to work with Benny Zabel, who's an 80-year-old performance artist. He's a long-standing peace and environmental activist, and you should Google him if you have the time. He's you know, essential. He's been wearing his face mask and costume as part of his political expression since the 80s. He was famously part of this big protest in Australia, the Franklin River Dam blockade, which was to save the Franklin River Dam in Tasmania. And so, you know, Benny speaks a lot about how the face mask part of his costume is the means by which he communicates his political message. And he spoke about in the case the effect of the mask removal powers on that form of political expression. We don't have a lot of human rights protected in our constitution, but we do have the right to political expression. So it was because of Benny that we were able to bring the constitutional challenge. And ultimately, the government didn't pass the blanket mask ban, but they introduced these designated area powers instead, I think, or soon after they were passing sort of a very watered down protest laws. And because we had already been engaged with Benny and with MALS, and because MALS had already been documenting for so many years this issue of designated area powers being used at protests, we were then able to quickly get up a legal challenge. And I know that we're running out of time a bit, so I won't go through all the ins and outs of the case, but one of the really, you know, it wasn't just that MALS connected us with one plaintiff in the proceedings, because of course these proceedings often take twists and turns. And on the same day that our evidence was due in the matter, Victoria Police tried to make the matter go away by ending the declaration early, which could have been a success, but then they also told us that they were going to remake another declaration at an unknown time. And so this posed, you know, can't speak to the reasons why they did that, but it posed a standing issue for our two clients in the matter, because whilst they were potentially going to be subject to the declaration by attending protests within that period, they hadn't been stopped or searched or unmasked in that current declaration. So we, within the space of a weekend, needed to find someone who had been impacted by the declaration that had been in force for about, I think, less than a month, but at that time. And because MALS had been attending protests during that period and engaged with protest organisers, they then had a network which they could rely on to assist us to find people who were affected by the designated area powers. We were put in touch with our third plaintiff, who miraculously was not only stopped and searched after attending a protest within the designated area powers, but had recorded the information, had recorded the entire interaction on his phone. He knew that there was a declaration because the work of not just MALS, but other civil society groups in saying that there was a declaration in force. He knew something was in place. He filmed the interaction, and he also kept the piece of paper which police handed him during the search, which was incredibly helpful because there was just no doubt that he was searched under the laws and he was searched unlawfully, which I think helped set the tone in the case. And we knew from MALS that this was common, that activists were searched unlawfully using these powers. So I'll sort of stop there, but I think the case provides a really, and I'm not from MALS, but I think it provides a really clear example of how protest monitoring and strategic litigation can intersect, and how that evidence base that is gathered on the ground at protests can be then used in legal proceedings. And we referred to MALS reports copiously in our submissions. We only knew the dates that, even for our clients who recalled being, these powers being used against them at protests, it's because we were able to line up different pieces of evidence and present them to the court, that we had sort of a chronology of how these powers were used. So yeah, really, really critical documentation work. And I don't think the case would have been able to proceed without that infrastructure that legal observers provide. So yeah, hats off to all the legal observers here.
Thanks so much, Sarah. I think that was a really excellent way to end our presentations, because I think it ties back quite nicely to what Illan was talking about in terms of the role of the legal observer and how they are quintessential to protecting the right to protest, both on the day, but also more long term, like in class action lawsuits. So we're really grateful that you were able to join and speak to this experience. It's really interesting to hear about the different litigation you pursue. ICCL does not pursue a strategic litigation outside of our digital rights team. So it's really interesting to see how legal observers contribute to that in different jurisdictions. Now, we have 7 minutes left. If individuals have questions, I know we went a little over time, but everyone's presentations are just too compelling. I didn't want to cut people off. So if anyone has any questions, feel free to put them in the chat or to use the raise hand function.
There's one really interesting kind of interaction between Francesca and Maria in the chat around the Human Rights and Equality Commissions. Francesca, I wonder, do you want to say something about the Latin American experience? Would that be possible?
Sorry,
very briefly, as I see that there is Aiden that was asking a question.
Apologies.
I don't know if you want to go with them first.
Sure. Yeah.
Yeah, Eden, we can go with you first, and then maybe we can move to Francesca.
Yeah. Hi, everyone. I'm glad to be here. My name is Eden. Well, as you can see, I'm the Director of Right to Protest at the Association for Civil Rights in Israel. I don't have a very specific question. What I want to say is basically that I'm not sure if this framework of legal observers exists in Israel-Palestine in this form. And if it doesn't, then I would absolutely love to find a way to help develop it here. It sounds like a very important and useful thing for especially of course for Palestinian protesters or for Jewish protesters in support of Palestinians and opposing the genocide and ethnic cleansing. So I just wanted to ask in a very general sense, first, if I could be in touch with any of you or other people from your organizations, and secondly, if there's anything as a very initial answer, what should I know about what you need to do in order to build up this kind of network, if that is a thing that still needs to be built up here.
Yeah, thanks so much for joining, and I'm really happy you're interested in setting one up. Illan might know more information about potential legal observer projects that are already set up and running in Israel or Palestine. But if you want to set one up yourself, we're happy to provide guidance on how to do so. I think one of the first decisions you need to make is what model you're going to use. So are you going to train individuals from social movements to do this? Are you going to have lawyers to do it? or are you going to have like staff members from ACRI do it, for example? So we can actually we can put in the chat the link to our article that we wrote on establishing the Legal Observer Network, because that goes into great detail about why we chose which method and what benefits and challenges come with each way of doing it. And I think that might be really helpful for you to just sit down and think about what will be best for your context. And we're happy to chat at any time if you have specific questions after that. Illan, I don't know if you want to add anything else.
No, I don't have any. None of the organizations. I mean, there's plenty of human rights monitors, obviously, in Israel, Palestine, and a lot of like absolutely essential work going on. We had the director of Al Haq here recently, and they obviously have been doing a ton of work. I guess I don't think they have been doing work around protest, at least not since the March for Return a number of years ago. So. Yeah, so nothing. I don't know if there's anybody else has any examples of protest-oriented activism in Israel, Palestine, but no. But yeah, happy to help if we can.
Okay, thank you so much.
No
Thank you.
problem. We can also, we have developed a little training guide, which is essentially our training compiled into this little booklet. So we can send this on as well. And I think that will really help you figure out just the right way to do it.
Yeah, that would be great. Thank you.
No problem. Okay, maybe we'll turn now to Francesca about the potential role of national human rights institutions.
Thank you. Yes, I asked this in the chat because indeed this is something that is coming up more prominently, that national human rights institutions in general, in all their different shapes, because we are talking also about like defenders of people, ombuds people, etc. They, based on the 1993 UN resolution of the General Assembly of the UN, which also better known as Paris Agreements, they laid out the competencies that the mandate of these institutions should have. And one cluster of competencies focuses heavily on the power to monitor, for example, protests or assemblies. And we are in touch with academics, researchers that have conducted this or have tried, even within the Council of Europe themselves, they reached out to the NHRIs. And it was obviously in some countries there are not even fully fledged NHRIs. I come from a country which it doesn't even have one, Italy. So, but in those countries where they exist and they are accredited to the European national rights institutions or the GANRI, the global one, they technically, if they are accredited, depending on the type of accreditation that they have, they should also have this power to monitor. And when we went to look at those that actually used it, we saw that there is a lot of countries in Latin America have been doing it. And I was, picked by, I was triggered also by the excellent description that Illan gave about the different phases of the legal observership, before, during, and after. This is exactly what they do. They start the dialogue before, but then they intervene there. They write a report. They issue recommendations, what worked and what didn't work. And this is something that we thought that we should. I mean, in France, it happened a couple of times that the defender of rights was a woman. She was also a former journalist. Maybe that's what pushed her, but she used this power to send. Unfortunately, the problem that, even in those cases where they are willing to use these powers in Europe, sometimes the issue is that they can't monitor all the protests. They don't have capacity. They have to prioritize, which is why one thing, that doesn't diminish the importance of your project. But it's something additional because it would add gravitas, it would add, a cooperation. And maybe if these powers don't exist or are not used, you could advocate for this. And I've promised Maria that I will send research. If you want, I can share it with everyone.
Yeah, that would be really helpful. I'd be really curious to read what the Latin American NHRIs have been doing.
Yes.
So The Irish NHRI, for example, has multiple monitoring powers under different UN human rights treaties. So they are the monitoring mechanism under the CRPD and will likely be the coordinating body under any future national preventative mechanism under OPCAT. But if anyone knows anything about Ireland and OPCAT, we've been fighting for this for nearly 20 years and we still not have ratified it.
If I may quickly say, recently I asked the same questions, of the Danish human rights institutions, because they're having huge problems with protests, the he say, she say, the police is violent, and only recently did the journalist post a video and then made the uproar. They also they themselves, the Danish institute that does have the power, they fell from the tree because they said, you know what, we never thought about it.
Yeah.
And so it's something to be considered, probably.
Yeah, definitely. And actually, we at ICCL are quite lucky because the chief commissioner of our NHRI is our former executive director. So we do have a great relationship. But I think there are many capacity issues in terms of the Irish NHRI because they also have a power to do inquiries under the Act, which I don't think has been exercised since the Act came into force in 2014. But it's definitely something to consider and we can look at it. Thank you so much for raising that, Francesca. Illan, I don't know if there's anything else you want to add?
Well, no, just on that, I think that's right that the two can work potentially together. I don't think one would replace the other at all, even if there was capacity at the Irish Human Rights and Equality Commission. I think it would ultimately there's a value in engaging civil society and social movements in human rights protection, which can't be kind of overtaken by a kind of more classically state institution. So I think you're absolutely right that connecting the two, but also keeping them running in parallel, I think is a kind of nice model to adopt. Which Yeah, I wonder, is there any insight from the Australian, like, is there a similar national human rights body that would do something like that, or are they captured or, quietist or uh,
There is the Australian Human Rights Commission. I think that, generally they have a much more kind of removed reporting function. So people submit complaints to them and they oversee them. Their powers are quite constrained because we don't really like human rights in Australia. There is a bit of a push at the moment to have a National Human Rights Act, which, if it was instituted, perhaps there would be a broader conversation to be had around systematic monitoring of how state agencies carry out their human rights related functions. But yeah, not for the moment.
Thank you. Maybe we've gone slightly over, so thank you all for your patience. Emily, should we?
Yeah, I think this is a great point to close. I think we've covered a lot of really important information today, and I will send on everyone the article we mentioned and also the training guide. Thank you all for coming. If you have any further questions or want advice on potentially setting up your own Legal Observer project, please don't hesitate to reach out. We'd be happy to chat.
Just one other thing. I wonder, it's really might be helpful because I think to have some shape or form of informal network internationally where we're sharing these experiences, and like I have in the background some of the links there that were shared, like the Australian Democracy Network, and I think absolutely I think it's essential that we all learn from each other's experiences around this, particularly the projects like the Melbourne and the New South Wales experiences where they're really far advanced in these things, and I think that would be really helpful. I don't know how we organize that. The thought of organizing another network fills me with dread, but
we can email you. Yeah, we actually have a catch up with Green and Black Cross, kind of on the regular now.
Great.
So please come along to that.
That would be fantastic.
If that's politically appropriate. I don't know about that.
Definitely. Yeah. Very happy to attend that. Yeah.
All right. Thanks so much, everyone.
Thank you. Bye, everyone.